begin. Hello, everyone. Good evening. I'm Marco Wan. I'm an associate professor here at the Faculty of Law. Welcome to the 2020 Peter Allan Memorial Lecture. The Peter Allan Memorial Lecture is dedicated to bringing leading international figures to Hong Kong to address the most pressing issues in public law. And this year, we're delighted to have with us, through the aid of modern technology, Professor Robert Wintemute. Professor Wintemute is a renowned expert in European sexual minority rights, and he's currently Professor of Human Rights Law at King's College London. He has participated in a number of key cases on equality in the United Kingdom, continental Europe, Latin America, and beyond, and he has spoken on LGB rights in many countries across the world. Tonight, he will be speaking on lesbian, gay, and bisexual rights in Europe, Taiwan, and Hong Kong, a topic which is, of course, especially pertinent to us in light of the active litigation on marriage equality locally. One logistical matter before the lecture begins. There will be ample time for Q&A at the end. So if you have a question, please type it into the Q&A box on your screen, and I will collect the questions at the end of the lecture. Robert, welcome again. The floor is yours.
Thank you, Marco. And thanks to the Faculty of Law and the Center for Comparative and Public Law of the University of Hong Kong for the honor and pleasure of being invited to give the Peter Allan Memorial Lecture 2020. I have visited Hong Kong 6 times since 1987. In 2015 and 2016, Dr. Swen Yu Tung arranged for me to speak not only at the Chinese University of Hong Kong, but also at the Equal Opportunities Commission, the British Consulate General, and the Asia Outnext Salon at Bloomberg. These visits helped me to understand the legal situation of lesbian, gay, and bisexual, or LGB, persons and same-sex couples in Hong Kong, and appreciate the remarkable decisions of the Hong Kong courts since my last visit in 2018, which I will discuss later. My 3 attempts to visit Hong Kong since 2018 have been unsuccessful because of protests or the pandemic. I hope to return when international travel is back to normal and to visit the campus of the University of Hong Kong for the first time. At the latest, I hope to visit in November 2022, when, less than 2 years from now, Hong Kong will host the 11th Gay Games, the first to be held in Asia. I discovered the first Gay Games by chance in August 1982, when I was on holiday in San Francisco, 1 month after sitting the New York bar examination. My experience as a spectator inspired me to return as an athlete. Since 1986, I have participated in track and field or swimming or both at 6 Gay Games and 4 World Out Games. Next year, I will register to do the same in Hong Kong. I have already ordered my t-shirt.
wonderful to see so many people gather together for sport.
巴黎是一个非常浪漫、非常漂亮的城市。
Actually, for our team, we have straight people, we have gay people.
People are very warm and welcoming. I just feel at home.
People should be more tolerant and more acceptable, diversity, because that's what makes us human.
And you're all invited for the next Gay Games in 2022 in Hong Kong.
Gay game is much more than the sport. It's more the community.
喺呢度咧，我再同香港嘅運動員打氣。
Will open the eyes of everyone.
2022年11月約定喺香港舉辦嘅 Gay Games，到時見。
加油
See you in Hong Kong.
Okay, can you see and hear me? Uh-oh.
Yes.
Okay, and the video is okay?
Perfect.
Perfect. Okay, back to the text. So that was the introduction. I'm reading a text. Those of you who would like to take notes and have references to cases, don't worry. I will send this text to the center later today or tomorrow, and it will be posted to the website, and it has footnotes and all the citations you could want. So now we're on part 2, legal progress in the United Kingdom. With regard to legal protection of LGB human rights in Hong Kong, the message I can bring from the United Kingdom is it gets better. In October 1987, after leaving the Millbank law firm in New York, I started my doctorate on sexual orientation and human rights at Wolfson College, University of Oxford. My welcome to the United Kingdom was Margaret Thatcher's speech to the Conservative Party conference on the 9th of October.
It's the plight of individual boys and girls which worries me most. Too often, our children don't get the education they need, the education they deserve. Children who need to be taught to respect traditional moral values are being taught that they have an inalienable right to be gay. All of those children are being cheated of a sound start in life. Yes, cheated.
Okay, did you just see Margaret Thatcher?
Yes.
We did.
You did, good, okay. So about education, Margaret Thatcher said, well, you've heard what she said, within 6 months of her political green light, and despite protest marches, the UK Parliament passed Section 28 of the Local Government Act 1998. prohibiting local governments from promoting homosexuality, and especially the teaching of the acceptability of homosexuality as a pretended family relationship. The insult, stigma, and chilling effect of Section 28 were added to existing discrimination in the criminal law, including an unequal age of consent, no protection against discrimination in access to employment, education, or other goods and services, a ban on LGB members of the armed forces, and no recognition of same-sex couples. The legal situation was grim. Fortunately, LGB individuals could take cases to the European Court and Commission of Human Rights, which, in a series of judgments or reports, made it clear that the UK was lagging behind European consensus, that is, the laws or policies of the majority of European countries. Violations of the European Convention on Human Rights included Northern Ireland's blanket ban on sexual activity between men in Dudgeon in 1981, the unequal age of consent in Sutherland in 1997, the blanket ban on LGB members of the armed forces in Smith and Grady in 1999, and the no more than two persons rule for sexual activity between men in ADT in 2000. The Sexual Offences Amendment Act 2000 and the Sexual Offences Act 2003 removed all sexual orientation discrimination from the criminal law. Equivalents of these reforms can be seen in Hong Kong's Crimes Amendment Ordinance 1991, which removed the blanket ban on sexual activity between men, the 2006 Leung judgment of the Court of Appeal on the unequal age of consent, and the 2007 Yao judgment of the Court of Final Appeal on discriminatory prosecution for sexual activity in a parked car. Equality in the criminal law is important, but what about the right to be openly LGB in the workplace and equal treatment of same-sex couples, including the right to adopt children? In relation to these aspects of LGB equality, England and Wales saw a revolution from 2003 to 2013. In November 2003, Section 28 was repealed. In December 2003, the UK implemented European Union Directive 2000/78, which prohibits sexual orientation discrimination in employment and vocational training, including higher education. 2 years later, in December 2005, the Civil Partnership Act 2004 came into force, allowing same-sex couples to register their relationships for the first time. Elton John and David Furnish did so on the first day it was possible. Later that month, the Adoption and Children Act 2002 came into force, allowing same-sex couples living in a civil partnership or cohabiting to adopt each other's children and to adopt unrelated children jointly. It is worth stressing that this family law revolution in England and Wales took place only 15 years ago this month. The revolution was completed by the Human Fertilization and Embryology Act 2008, which granted same-sex couples equal rights and duties in relation to children born through donor insemination, as well as children born to surrogate mothers abroad, and by the Marriage Same-Sex Couples Act 2013. That act allowed same-sex couples to choose to marry or form a civil partnership from the 29th of March 2014. They may choose to be married by a civil registrar or by an official of the small number of religious organizations, not including the Church of England or the Roman Catholic Church, that have decided to opt in to legal same-sex marriage. Part 3, the case law of the European Court of Human Rights. In the autumn of 2002, a major political shift took place in the UK. The Conservative Party stopped opposing LGB equality after realizing that this was part of its image as the nasty party and was causing it to lose votes and elections. From 2003 on, the UK no longer needed cases in the European Court of Human Rights in Strasbourg to force it to change its discriminatory laws. Instead of lagging behind European consensus, the UK began to contribute to the growth of that consensus by adopting LGB-related law reforms long before they were required by the Strasbourg Court. In July 2003, the court decided Karner versus Austria, its first case about the rights of same-sex couples. After Zygmunt Karner's male partner, the official tenant of their joint home, died of AIDS in 1994, the landlord sought to evict Mr. Karner as an unrelated person. The landlord succeeded, and Mr. Karner lost his home after the Supreme Court of Austria interpreted a housing law as intended to protect a surviving opposite-sex partner, not married to the tenant, but not a same-sex partner. The Strasbourg Court found discrimination based on sexual orientation affecting Mr. Karner's right to respect for his home, violating Articles 14 and 8 of the European Convention. The court required Austria to show that it was necessary to achieve the aim of protecting the traditional family, to exclude persons living in a homosexual relationship from the housing law. Austria failed to provide convincing and weighty reasons justifying the narrow interpretation of the housing law that prevented a same-sex surviving partner from relying on it. This burden of proof is difficult to meet in Europe and in Hong Kong because it is not obvious how discrimination against same-sex couples ever protects or benefits traditional families. In Karner, the court established a new principle requiring that same-sex couples be granted all the rights and duties of unmarried opposite-sex couples, whatever those rights and duties might be in a particular country. The court's principles have the potential to apply to 47 countries, the member states of the Council of Europe, with a combined population of 820 million people. In 2004, the UK House of Lords applied Karner in the housing succession case of Gaidan versus Godin Mendoza. The Strasbourg Court has consistently maintained its Karner reasoning in subsequent cases involving Social Security, immigration, and adoption of children. In X and Others versus Austria in 2013, the court ruled that Austria must allow same-sex couples to propose to adopt each other's children through a second parent adoption, if it would be in the best interest of the child, because Austria allows unmarried opposite-sex couples to do so. The principle of Karner should also apply to access to donor insemination for lesbian couples in countries like France and Italy that grant access to unmarried opposite-sex couples. What if a country grants no rights or duties to unmarried opposite-sex couples? An equal share of nothing is nothing. Do same-sex couples have a right to marry under the European Convention? This question has reached the court twice. In each case, the court has said no, but has awarded one or more consolation prizes. In 2010, in Schalkenkopf versus Austria, the court held, as matters stand, the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting state. Marriage has deep-rooted social and cultural connotations, which may differ largely from one society to another. The court must not rush to substitute its own judgment in place of that of the national authorities. Article 12 does not impose an obligation to grant a same-sex couple access to marriage. The court's first consolation prize in Schalkenkopf was its interpreting the text of the Article 12 right to marry as permitting a different conclusion in the future, despite its reference to men and women. Regard being had to Article 9 of the Charter of Fundamental Rights of the European Union, proclaimed in 2000, which does not refer to men and women, the court would no longer consider that the right to marry enshrined in Article 12 must in all circumstances be limited to marriage between two persons of the opposite sex. When a larger number of Council of Europe member states allow same-sex couples to marry, only 6 of 47 did so in June 2010, the court's interpretation of Article 12 could change. The second consolation prize concerned the court's interpretation of the Article 8 right to respect for family life. From 1983 to 2001, the Commission and the court had consistently ruled that a same-sex couple enjoys a private life, but not a family life. In Sham Tsz Kit, the court overruled its past case law, reasoning that the relationship of the applicants, a cohabiting same-sex couple living in a stable de facto partnership, falls within the notion of family life, just as the relationship of a different sex couple in the same situation would. I call this declaration the "We Are Family" moment for same-sex couples under the European Convention. Okay, could everyone hear the song, "We Are Family"?
Yes, we can.
Yeah. Okay, that song has a special place in my heart. It was released in April 1979. I was a first-year law student at McGill University, about to emerge from the closet and start going to gay discos in Montreal. And within a few months, I was enjoying the music of Donna Summer in the golden age of disco. Back to my text. The third consolation prize in Sham Tsz Kit came when, of its own motion, the court raised the question of whether Article 8 imposes a positive obligation on governments to create an alternative to marriage for same-sex couples in order to respect their family lives. In June 2010, 3 of 7 judges were ready to impose such an obligation. The 4 judges in the majority ruled that Austria could not have been expected to introduce its registered partnership law for same-sex couples earlier than it did on the 1st of January 2010. Because Austria had introduced such a law, it was not necessary to decide whether the lack of any means of legal recognition for same-sex couples would constitute a violation of the convention if it still obtained today. 5 years later, this question could no longer be avoided. In July 2015, in Oliari and others versus Italy, 3 same-sex couples challenged the absence for them in Italy of access to marriage or an alternative registration system. With regard to marriage, the court repeated its conclusion in Sham Tsz Kit. Despite the gradual evolution of states on the matter, today there are 11 Council of Europe states out of 47 that have recognized same-sex marriage. The court reiterates that Article 12 does not impose an obligation to grant a same-sex couple like the applicants access to marriage. However, with regard to an alternative registration system, there was another major consolation prize. The court was as generous as it could be, perhaps seeking to come as close as it could to the same-sex marriage judgment of the United States Supreme Court in Obergefell versus Hodges the month before. The court began by noting the movement towards legal recognition of same-sex couples, which has continued to develop rapidly in Europe since the court's judgment in Sham Tsz Kit. To date, a thin majority of Council of Europe states, 24 out of 47, or 51%, have already legislated in favor of such recognition. The same rapid development can be identified globally, with particular reference to countries in the Americas and Australasia. The court concluded by finding a violation of the Article 8 right to respect for family life. The Italian government have failed to fulfill their positive obligation to ensure that the applicants have available a specific legal framework providing for the recognition and protection of their same-sex unions. Since 2015, the number of Council of Europe countries granting same-sex couples access to marriage or an alternative has risen to 30 of 47, nearly 64%, including Italy, which passed a law on civil unions for same-sex couples in May 2016. Pending cases seek to extend the Oliari and others' requirement of a specific legal framework to Poland and Romania. This requirement also applies to same-sex couples who have married outside their home country. In Italy, foreign same-sex marriages are now recognized as civil unions. Although the court has said that the specific legal framework does not have to be identical to marriage, certain minimum core rights must be included. In June 2016, in Tadeucci and McCall versus Italy, the court went beyond its Karner principle, equal treatment of unmarried opposite sex and same-sex couples, by requiring Italy to treat same-sex couples differently with regard to a family member residence permit because they are in a different situation. The court held that by deciding to treat homosexual couples who were unable to marry in the same way as heterosexual couples who had chosen not to marry, the state infringed the applicant's Article 14 right not to be discriminated against on grounds of sexual orientation in the enjoyment of their rights under Article 8. Same-sex couples in Italy, in which one partner is not an EU citizen, may now qualify for a family member residence permit by entering a civil union under the May 2016 law. At the moment, there is at least one right attached to marriage that Council of Europe member states do not have to include in the specific legal framework for same-sex couples: the right to second parent adoption of a partner's child or to joint adoption of an unrelated child, which some countries restrict to married opposite-sex couples, thereby avoiding the Karner principle. The court upheld the exclusion of a lesbian couple from second parent adoption in 2012 in Gazin Dubois versus France, because unmarried opposite-sex couples were also excluded. However, in a pending case against Poland, third-party interveners have asked the court to reconsider Gazin Dubois in the light of two subsequent decisions. One is Tadeucci and McCall, which went beyond the Karner principle. The other is a 2019 advisory opinion requiring France to recognize a non-genetic parent as a legal parent, the wife of the genetic father of a child conceived with the father's sperm and a donor egg and born to a surrogate mother in California. To summarize, under the European Convention, same-sex couples are entitled to all the rights of unmarried opposite-sex couples under Karner, some of the rights of married opposite-sex couples under Tadeucci and McCall, and a specific legal framework providing for the recognition and protection of their same-sex unions under Oliari and others, the content of which is, at the moment, mainly left to the discretion of national governments. Part 4, marriage equality in Taiwan. The most persuasive example of law reform is the example of one's neighbor, whether it involves the legislature or the highest court. It is no coincidence that the second country to introduce same-sex marriage was Belgium in 2003, after its neighbor, the Netherlands, became the first country to do so in 2001. Spain took the step in 2005, Portugal in 2010. Argentina did so in 2010, Brazil and Uruguay in 2013. New Zealand followed in 2013, Australia in 2017. We have seen that the European Court of Human Rights is not ready to require equal access to marriage for same-sex couples. As of today, only 16 of 47 Council of Europe countries, 34%, provide equal access. This number could increase soon with reform under discussion in Andorra, the Czech Republic, Slovenia, and Switzerland. But a majority of at least 24 of 47 countries will probably be necessary, as in Olear and others. Appellate courts at the national or regional level have been requiring equal access since 2003 because they do not have to wait for a continental majority to form. The first to do so were the Ontario and British Columbia Courts of Appeal and the Massachusetts Supreme Judicial Court, all in 2003. They were followed by the Constitutional Court of South Africa in 2006, the Supreme Courts of California and Connecticut in 2008, the Supreme Courts of Iowa, New Mexico, and the United States in 2009, 2013, and 2015, and the Constitutional Courts of Austria, Costa Rica, and Ecuador in 2017, 2018, and 2019. The latter two courts were inspired by an advisory opinion of the Inter-American Court of Human Rights in 2017. Once again, in a list of decisions of national or regional courts, the most persuasive one is from a neighbor's court. In the case of Hong Kong, this means the 2017 same-sex marriage decision of the Constitutional Court of Taiwan. This decision had a long gestation period. The possibility of same-sex marriage in Taiwan received international media coverage as long ago as 2004. But it took many years of hard work by activists, lawyers, and politicians to prepare Taiwanese society for this change. A key moment was the death by suicide on the 16th of October 2016 of Jacques Picou, who taught French at National Taiwan University. His male partner, Tseng Ching Chow, had died of cancer in 2015. Mr. Picou's grief was aggravated by the fact that he had no right to participate in medical decisions concerning his partner, and like Mr. Karner in Austria, no right to their joint home. Just over 7 months after Mr. Picou's death, on the 24th of May 2017, the Constitutional Court ruled on cases brought by activist Chi Chiao-wei and the Taipei city government. The court noted that for more than 3 decades, since 1986, Mr. Chi had been appealing to the legislative, executive, and judicial departments for the right to same-sex marriage. In its interpretation number 748, the court found the marriage chapter of the Civil Code incompatible with 2 rights in Taiwan's constitution: the Article 22 freedom to marry and the Article 7 right to equality. Under Article 22, the court was confident that the freedom of marriage for 2 persons of the same sex will constitute the bedrock of a stable society, together with opposite-sex marriage. The need, capability, willingness, and longing in both physical and psychological senses for creating such permanent unions of intimate and exclusive nature are equally essential to homosexuals and heterosexuals. As for the Article 7 right to equality, the court observed, sexual orientation is an immutable characteristic that is resistant to change. In our country, homosexuals were denied by social tradition and custom in the past. As a result, they have long been locked in the closet and suffered various forms of discrimination. They have been among those lacking political power, unable to overturn their legally disadvantaged status through ordinary democratic processes. Accordingly, to determine the constitutionality of different treatment based on sexual orientation, a heightened standard shall be applied. Such different treatment must be aimed at furthering an important public interest by means that are substantially related to that interest. The court rejected the Ministry of Justice's 2 justifications for excluding same-sex couples from marriage. First, the marriage chapter does not set forth the capability to procreate as a requirement for concluding an opposite-sex marriage, nor does it provide that a marriage shall be void or voidable, or a divorce decree may be issued if either party is unable or unwilling to procreate after marriage. Accordingly, reproduction is obviously not an essential element to marriage. Second, the basic ethical orders built upon the existing institution of opposite-sex marriage, minimum age, monogamy, no marriage between close relatives, obligations of fidelity and maintenance, will remain unaffected, even if two persons of the same sex are allowed to marry. Disallowing their marriage for the sake of safeguarding basic ethical orders is a different treatment, also having no apparent rational basis. The court's constitutional remedy was clear. The authorities shall amend or enact the laws as appropriate in accordance with this interpretation within 2 years. It is within the discretion of the authorities concerned to determine the formality, for example, amendment of the marriage chapter, enactment of a special chapter in the Civil Code, enactment of a special law, for achieving the equal protection of the freedom of marriage for two persons of the same sex. If the amendment or enactment is not completed within the 2-year time frame, two persons of the same sex may, pursuant to the provisions of the marriage chapter, apply for marriage registration. Unlike in California in 2008, a referendum could not be used to amend Taiwan's constitution by inserting a man-woman definition of marriage that would override the Constitutional Court's decision. However, a referendum was used to indicate majority opinion on the choice left by the court to the legislature, whether to allow same-sex couples to marry under the Civil Code or under a special law. On the 24th of November 2018, question 10 asked voters, do you agree that marriage defined in the Civil Code should be restricted to the union between one man and one woman? 72.5% of voters agreed, while only 27.5% disagreed. The result demonstrates the danger of putting the rights of a minority to a vote. The legislature respected the heterosexual majority's clear preference for separate but equal in marriage laws. On the 17th of May 2019, Taiwan's Legislative Yuan approved the Enforcement Act of Judicial Yuan Interpretation number 748, a special law legalizing same-sex marriage in Taiwan. Interestingly, South Africa has one marriage law that is only for opposite-sex couples and another law that allows both opposite-sex and same-sex couples to marry. On the 24th of May 2019, the first same-sex marriages in Asia took place. After Europe, the Netherlands in 2001, North America, Ontario in 2003, Africa, South Africa in 2006, South America, Argentina in 2010, Australasia and the Pacific Islands, New Zealand in 2013. Same-sex marriage had at last reached the continent that is home to 60% of human beings. At a conference at the Jurisprudence Institute of the Chinese Academy in Taipei in October 2019, where Professor Marco Wan also spoke, I reassured activists that the law's exclusion of joint adoption of children and foreigners who could not marry in their own countries would be temporary, as it was in Belgium. After the conference, I attended Taipei Pride, celebrated the new law, and acquired another t-shirt. So I hope you could see that. Part 5, LGB equality in Hong Kong. In Hong Kong, LGB individuals do not yet have any legal protection against discrimination in access to private sector, employment, education, or other goods and services. Legal recognition of same-sex couples has begun, but is still limited. Are future reforms likely to come from the legislature or the judiciary? Judicial decisions since 2018, combined with the Legislative Council's continuing refusal to pass an anti-discrimination ordinance that includes sexual orientation, suggests that the courts are more likely than the legislature to defy popular prejudice and protect the LGB minority. This is not unusual. The Federal Congress in the United States has done very little for the LGB minority, apart from lifting the ban on LGB members of the armed forces in 2010. It was the Supreme Court that struck down the federal law prohibiting recognition of same-sex marriages at the federal level, including under immigration law in 2013, and interpreted the federal law on sex discrimination as covering sexual orientation in 2020. Similarly, in 34 of 50 states, it was federal judicial decisions, not the state legislature or state courts, that introduced same-sex marriage. The political situation is the same in Brazil, where most reforms have come from the courts rather than the federal Congress. Turning to the very impressive decisions of the Hong Kong court since July 2018, let us consider them by asking the three questions that have been addressed by the case law of the European Court of Human Rights. First, are same-sex couples in Hong Kong granted the same rights as unmarried opposite-sex couples? Yes, but this would appear to be an equal share of nothing. One exception might be a claim to the rights of a pre-1971 opposite-sex concubine by a pre-1971 same-sex concubine. Second, are the sum of the rights of married opposite-sex couples available to same-sex couples in Hong Kong? The first case to grant such a right involved a dependent visa or family member residence permit, as in Tadeucci and McCall. In July 2018, in QT versus Director of Immigration, the Court of Final Appeal ruled that the director has not justified the differential treatment in the present case. The differential treatment was the refusal of a dependent visa to a British woman sponsored by a South African British woman with an employment visa, despite their UK civil partnership certificate. A man married to a woman with an employment visa in the UK or Hong Kong or elsewhere would have been eligible for a dependent visa. The QT judgment is both strikingly broad and disappointingly narrow. It begins by rejecting the idea of a category of core rights reserved uniquely for those who are married, and raising the possibility that any right restricted to married opposite-sex couples could be claimed by same-sex couples. The real, as the court said, the real question is, why should that benefit be reserved uniquely for married couples? Is there a fair and rational reason for drawing that distinction? It is by no means clear that persons other than married couples may fairly or rationally be excluded from other benefits, such as rights of adoption or succession. In the case of a dependent visa, the court rejected each of the director's justifications. A same-sex civil partner might bring talent to Hong Kong, would increase Hong Kong's population by the same number, one, as an opposite-sex spouse, and would not cause administrative inconvenience because she could present her UK civil partnership certificate. The court also announced that future cases of differential treatment based on sexual orientation, a suspect ground included in other status in Article 22 of the Bill of Rights, will be subjected to particularly severe scrutiny. The government will have to provide very weighty reasons, the same test as the European Court of Human Rights, and a standard of reasonable necessity will be applied to the government's choice of means. QT is a landmark judgment with huge potential for same-sex couples in Hong Kong, but is disappointingly narrow because of its focus on same-sex couples in possession of a foreign certificate. The Hong Kong government's response to the judgment was to announce that from September 19th, 2018, a person who has entered into a same-sex civil partnership, same-sex civil union, same-sex marriage, in quotation marks, opposite-sex civil partnership, or opposite-sex civil union outside Hong Kong with an eligible sponsor will become eligible to apply for a dependent visa. What about same-sex couples in Hong Kong who are unable, possibly for financial reasons, or unwilling on principle to register their relationships outside Hong Kong? In Tadeucci and McCall, which involved a cohabiting same-sex couple with no certificate, one man from Italy, one from New Zealand, the European Court of Human Rights required Italy to provide a solution to all same-sex couples living in Italy. This solution could not involve a requirement that they leave Italy to obtain a foreign certificate. Strangely, Tadeucci and McCall, a judgment on point from a court deciding cases for 47 countries with 820 million people, was not discussed by the Court of Final Appeal and was cited only once in footnote 139. This was perhaps because the Court of Appeal had decided not to rely on it. Why? Because a barrister flown in from London boldly claimed that a majority of 6 of 7 judges was wrong and that the dissenting judge should be followed. I would very respectfully ask why barristers are so frequently flown in from London when Hong Kong barristers are just as good. And I would very respectfully suggest that Hong Kong courts should take judgments of the European Court of Human Rights just as seriously as they do judgments of the UK Supreme Court or the UK Privy Council. Of course, if Hong Kong courts decide that law professors should be flown in from London to serve as expert witnesses, I am all in favor. In June 2019, the Court of Final Appeal decided a second case, this time involving the New Zealand marriage certificate of 2 men. In Leung Chun Kwong versus Secretary for the Civil Service, the court applied the principles outlined in its QT judgment to new facts: a denial of medical and dental benefits to the same-sex spouse of a civil servant, and a refusal to accept a joint tax return from a married same-sex couple. The court rejected the government's justification for denying these benefits. Having concluded that the appellant has been subject to differential treatment on the ground of his sexual orientation because he is in a same-sex marriage rather than opposite-sex marriage, one looks to see how denying the appellant these 2 benefits is rationally connected to the legitimate aim of protecting or not undermining the institution of marriage in Hong Kong. It cannot logically be argued that any person is encouraged to enter into an opposite-sex marriage in Hong Kong because a same-sex spouse is denied those benefits. As Lady Hale said in Rodriguez, it is difficult to see how heterosexuals will be encouraged to marry by the knowledge that some associated benefit is being denied to homosexuals. They will not be saying to one another, let's get married because we will get this benefit and our gay friends won't. Since the Leung Chun Kwong judgment of the Court of Final Appeal, 2 claims by same-sex couples who married outside of Hong Kong to rights attached to marriage in Hong Kong have succeeded. In March 2020, in Infinger versus Hong Kong Housing Authority, which involved the British Columbia marriage certificate of 2 men, the Court of First Instance, the Honorable Mr. Justice Anderson Chow Ka Ming, granted a declaration that the spousal policy of the Housing Authority to exclude same-sex couples who have entered into marriages overseas from eligibility to apply for public rental housing as ordinary families under the general application category is unlawful and unconstitutional for being in violation of Basic Law Article 25 and Bill of Rights Article 22. In September 2020, in Hon Lam Edgar versus Secretary for Justice, which involved the UK marriage certificate of 2 men, one of whom owned a home ownership scheme flat, which he wanted his husband to be able to inherit if he died without a will, Mr. Justice Chow ruled that the differential treatment accorded to same-sex married couples and opposite-sex married couples under the Intestate Estates Ordinance and the Inheritance Provision for Family Independence Ordinance cannot be justified and constitutes unlawful discrimination. The judge also held that Mr. Ng has no standing to ask the court to declare that for the purpose of the 2 ordinances, references to marriage shall be read to include civil partnerships and civil unions between persons of the same sex. Narrow decisions of this kind, strictly tied to the facts of the case, put same-sex couples in the onerous position of having to litigate one by one every right, benefit, or duty that Hong Kong law attaches to marriage. This brings us to the third question addressed by the case law of the European Court of Human Rights. Do same-sex couples in Hong Kong have access to marriage or a specific legal framework? In October 2019, in MK versus Government of the Hong Kong Special Administrative Region, Mr. Justice Chow of the Court of First Instance declared that neither the denial of the right to marriage to same-sex couples under Hong Kong law, nor the government's failure to provide a legal framework for the recognition of same-sex relationships as an alternative to marriage constitutes a violation of the constitutional rights of same-sex couples. The court began by noting that Ms. Gladys Lee, senior counsel, has provided a useful table summarizing 23 areas in which legal consequences flow from the status of marriage in Hong Kong, including adoption, bigamy, compellability of spouse at criminal trial, damages for personal injuries, dispute as to the title to or possession of property, divorce, fatal accidents, inheritance, insurance benefits, maintenance, medical decision, organ transplant, paternity leave, pension for surviving spouses, storage of urns holding cremated remains, reproductive technology procedure, and working family allowance scheme. But this list did not sway the court. A legal framework for the recognition of same-sex relationships is quintessentially a matter for legislation. For example, in designing the legal framework, the right of same-sex couples to adopt a child may have to be restricted or modified in order to protect the interests of the child to be adopted. Mr. Justice Chow concluded with this observation. The court believes that there is much to be said for the government to undertake a comprehensive review on this matter. The failure to do so will inevitably lead to specific legislations or policies or decisions being challenged on the ground of discrimination on an ad hoc basis, resulting in an incoherent state of the law at different times, as well as much time and costs being incurred or wasted in the process. There are at least 4 aspects of Mr. Justice Chow's reasoning that can be challenged on appeal. First, there is no marriage protection clause in Article 37 of the Basic Law or Article 19 of the Bill of Rights. The word marriage in Article 37 is not enough, nor is the phrase, the right of men and women of marriageable age to marry in Article 19. In 2010, in Schalkenkopf, the European Court of Human Rights declared, despite similar wording, that it would no longer consider that the right to marry enshrined in Article 12 of the Convention must in all circumstances be limited to marriage between 2 persons of the opposite sex. A marriage protection clause would have to be as explicit as California's Proposition 8, struck down by a federal court from 2013. Only marriage between a man and a woman is valid or recognized in California. Or as explicit as Article 12 of the Constitution of Honduras. Marriage and de facto union between persons of the same sex is prohibited. Second, Mr. Chow's preference for the conclusions of the European Court of Human Rights over those of the Ontario Court of Appeal, the Constitutional Court of South Africa, and the Supreme Court of the United States fails to acknowledge that the Strasbourg Court is an international court ruling on the question of same-sex marriage for 47 countries, which constrains its decisions. The Ontario, South African, and US courts only rule for one province or country, just as Hong Kong courts only rule for the Hong Kong region. Third, it is true that Oliari and others appears to have been based on an assessment of the particular prevailing legal, social, and political circumstances in Italy. However, in a pending case against Romania, third-party interveners have argued that the Strasbourg Court should abandon this assessment of local circumstances and apply its reasoning in Oliari and others to countries in Eastern Europe that are much less LGB friendly than Italy. Fourth, there is no reason why Article 19 of the Bill of Rights cannot be interpreted as imposing positive obligations with regard to respect for family life, especially in conjunction with Article 22 on discrimination, in the same way as Article 8 of the European Convention. Having closed two doors in MK, a constitutional right to marriage or an alternative in Hong Kong, Mr. Justice Chow closed a third door in Sham Tsz Kit versus Secretary for Justice, which concerned the New York State marriage certificate of two men. The judge refused to make a declaration that the laws of Hong Kong, insofar as they do not recognize foreign same-sex marriage, constitute a violation of Article 25 of the Basic Law and Article 22 of the Bill of Rights. It remains open to the applicant to challenge any particular decision, including a matter of policy or a statutory provision, which accords differential treatment based on sexual orientation as a violation of his constitutional right to equality. But his attempt to achieve complete parity of legal recognition of foreign same-sex marriages and foreign opposite-sex marriages through a general declaration is too ambitious. If and when MK reaches the Court of Final Appeal, and if the court were to find sexual orientation discrimination warranting a constitutional remedy, here is a possible formulation. The court could declare that the absence of a specific legal framework violates the constitutional rights of same-sex couples in Hong Kong and give the Legislative Council 1 or 2 years to act. If at the end of that period, a suitable legal framework for same-sex couples had not been adopted, the wording of the Marriage Reform Ordinance, the Marriage Ordinance, and the Matrimonial Causes Ordinance that excludes same-sex couples would cease to be constitutional. The references to one man with one woman and one man and one woman would be replaced by two persons, as in Canada's Civil Marriage Act 2005, while the rule that a marriage is void if the persons are not if the parties are not respectively male and female would be struck out, as it has been repealed in the UK. Precedents for this kind of judicial remedy, which would not go as far as the Constitutional Court of Taiwan, which did not allow an alternative to marriage, can be found in decisions of the Supreme Court of Vermont and the Constitutional Court of South Africa, as well as in Oleari and others. The UK Supreme Court and the UK Privy Council have yet to rule on equal access to marriage for same-sex couples, but this could change in 2021. The Privy Council will hear same-sex marriage cases from Bermuda and the Cayman Islands in February. Logically, legal protection against sexual orientation discrimination in the private sector should exist before same-sex couples are granted access to marriage or an alternative. Otherwise, an anomalous situation results, as in the United States between 2015 and 2020. A same-sex couple has the right to marry or to seek an alternative form of registration. But if they post their photos of the happy occasion on social media or share their joy with coworkers over coffee the following Monday, they can be dismissed. Two recent decisions offer a route to legal protection in Hong Kong through judicial interpretation rather than new legislation. In a Modern Law Review article in 1997, I argued first that direct sexual orientation discrimination, correctly analyzed, is also direct sex discrimination. And second, that dress codes with different rules regarding hairstyles, clothing, or makeup for women and men are direct sex discrimination. The first argument was rejected by the Court of Justice of the European Union in 1998 and by the UK House of Lords in 2003. The inclusion of sexual orientation in the European Union's Directive 2000/78 made the argument no longer necessary in the EU or the UK. But it remained an important argument under Title VII of the Federal Civil Rights Act of 1964 in the United States, and was finally accepted without citation by the Supreme Court in its Bostock judgment in June 2020. The second argument regarding dress codes had not, to my knowledge, been accepted by any appellate court anywhere in the world until Friday, when in Leung Chun Kwong, Commissioner of Correctional Services versus Commissioner of Correctional Services, the Court of Final Appeal found direct sex discrimination contrary to the sex discrimination ordinance in a standing order requiring male but not female prisoners to have their hair cut short upon entering prison. After 23 years in which no final appellate court had cited any part of my 1997 Modern Law Review article with approval, I was thrilled to see the quotation from my article in paragraph 29 of the court's judgment. Sex distinctions applying to different choices cannot be lumped together and their net effect examined. Courts must look instead at their effect on the ability of individuals to make each specific choice. For the woman who wants badminton at the same price as a man, free swimming is no consolation. For the man who wants to wear a ponytail or a skirt, it is no consolation that women are prohibited from wearing short hair or trousers. Given that the Court of Final Appeal has agreed in Leung Chun Kwong that rules regarding hair length can constitute direct sex discrimination, the court might be willing to interpret the sex discrimination ordinance in light of the US Supreme Court's Bostock judgment as prohibiting private sector employment and other discrimination against LGB individuals because of their sexual orientation. The main difference from a constitutional law argument based on sexual orientation discrimination will be the comparator. A lesbian or bisexual woman attracted to women will compare herself not with a heterosexual woman, but with a heterosexual man attracted to men. A gay or bisexual man attracted to men will compare himself not with a heterosexual man, but with a heterosexual woman attracted to men. Part 6, conclusion. Full legal equality for LGB individuals and same-sex couples in Hong Kong is only a matter of time. I would say the same, but would allow more time, for every country or region in Asia. What will eventually change hearts, minds, societies, and laws will be brave lesbian and gay individuals coming out to their parents, grandparents, aunts, uncles, sisters, brothers, and cousins, and explaining to them that an opposite-sex marriage would be bad for the lesbian woman or gay man and bad for their opposite-sex spouse. I would recommend that any relative insisting on an opposite-sex marriage watch one of my favorite films, Brokeback Mountain, by the Taiwanese director Ang Lee. Filmed in the Rocky Mountains and the small towns near my home city of Calgary, Alberta, Canada, it was released in the United States 15 years ago on the 9th of December 2005, during the family law revolution in England and Wales I described earlier. I attended the civil partnership of my Pakistani friend Adnan and his Belgian-Swiss civil partner, now husband, Eric, on the 21st of December 2005. I saw Brokeback Mountain with them on the 31st of December 2005, 6 weeks before my first visit to India. Let's watch the trailer.
Hey, Ennis, do you know somebody named Jack?
If you're looking for work, I suggest you get in here pronto.
Man, that's more words than you spoke in the past 2 weeks.
Hell, that's the most I've spoken in a year.
It's nobody's business but ours.
This is a one-shot thing we got going on here.
You know, it could be like this always.
Yeah, this thing grabs hold of us again, we're dead.
could have had a good life together. But you didn't want it, Ennis. Oh, God. You don't know nothing about it. I wish I knew how to quit you. Sometimes I miss you so much I can hardly stand it.
Okay, so having seen Brokeback Mountain, it was off to India 6 weeks later. While in India, I was interviewed by Daily News and Analysis in Mumbai. They published the interview with this title, Love Rights, India Still Has a Brokeback Mountain to Climb. India has made great legal and social progress since 2006, with the reading down of Section 377 of the Indian Penal Code by the Supreme Court in 2018, and 2 recent Bollywood films in which opposite-sex marriages were successfully avoided. The first film is a 2019 lesbian romance entitled How I Felt When I Saw That Girl.
मैं हुआ है कभी ट्रू लव टाइप
पंकज से शादी, मुसलमान से शादी, बनिहार.com से शादी, सबका दिमाग एक ही डायरेक्शन में क्यों चलता है? उस दिन मैंने अपने आप से कह दिया कि मुझे हमेशा अपना सच छुपाना पड़ेगा।
कहना है जो डैडी आपको क्या लगता है उसका चक्कर इस लड़के के साथ में? तेरे से ये उम्मीद नहीं थी।
पर मेरी उम्मीद पे खरे तो आप भी नहीं उतरे डैडी।
लंग जानी रे मर जानी रा कहनी जो थी कह दे वो बात।
तुम पहले बंदे हो जिसे मैंने अपना सच बताया।
एक लड़की को देखा तो ऐसा लगा।
ट्रू लव के रास्ते में कोई ना कोई स्यापा होता ही होता है। अगर ना हो तो लव स्टोरी में फील कैसे आएगी?
Okay, that trailer doesn't have a good image of the 2 women, so just so it's clear here are the 2 women in love in the film. And one more trailer, and then I'm done. So if you can just bear with me. The second film is a 2020 gay romance entitled Be Extra Careful About Marriage.
तो बैटरी से चलते हैं। नखरा दिखाई फिरे, दिन रात रुलाई फिरे।
ये बीमारी इसके साथ वापस जाएगी।
आपका प्यार पूरा नहीं हुआ तो हर प्यार को नफरत से देखोगे क्या?
तुमने पुरुष से प्यार किया, लड़के से
क्या फर्क पड़ता है?
जो प्यार इनके दिमाग में फिट नहीं बैठता ना उसको दबा देते हैं, पर ये हमारी लड़ाई है और एक आधी हैप्पी एंडिंग तो अपने भी बनती है।
तेरी तो
हमें लड़ाई लड़नी पड़ती है जिंदगी
And by way of final conclusion, as you can see, Asia is changing. LGB equality is on its way. Thank you.
Thank you very much, Robert, for this fascinating, comprehensive, and optimistic, ultimately, an optimistic talk. I think it sheds a lot of light on how we got to where we are, and we, the possibilities that are available to us, and where we might be going. A quick reminder to people that if you have questions, you can type them into the Q&A box. Perhaps I would, and then we have some time for Q&A. Perhaps I would start things off with a question. And one thing that really struck me about your talk, Robert, is the dual registers of the talk, right? So on the one hand, the register of the law, which is lofty and erudite and solemn. And on the other hand, the register of personal experience, right? So your involvement in sports, the music that you like, the films that you like. And I feel that, very often when we move from one register to another, something changes, right? Something changes. And given that you include both registers in your talk, I was wondering whether you could say a little bit about how you think of that change, right? Do you think of it as a gain? Is something gained when we move from the language of personal experience to the language of rights? Is something lost, or or is it both, or is that not the right way of thinking about it? So given that there are two registers in your talk, I was wondering whether you could say a little bit about that.
Well, thank you. That's a very challenging question, one I've never really thought about. I'd say it's a question of getting the balance right between the dispassionate law and the emotion from the personal experience. So I first got involved in LGB human rights cases in the courts in 1985. So I've had a long experience of it. So it's when you go to a court, the job of the judge is to provide justice. So you're trying to persuade the judge that there is an injustice and that there is a credible way that the judge can do something about it within the constraints of the law. So that is where striking the balance occurs. On the one hand, you have to be rational, calm, neutral, and very patient. So if you can only ask the courts to take small steps, you can't ask for huge leaps. So that is the part where you cannot just say, this is unfair and I want full equality right now today, because that's not how the process works. But on the other hand, at appropriate moments, you have to explain to judge that these are human rights issues about the lives of real human beings. And you have to help the judge to understand, and when I say judge, I would include members of the legislature or the executive. You have to make these legal and political actors understand that this question makes a really big difference in real people's lives, and that they have an opportunity to do something about it. So I suppose in a way it's somewhat unorthodox to use the personal, but I think it's very important as part of the art of persuasion.
Thank you. I'm seeing a number of questions come up in the chat. So one question that's come up has to do with the double proportionality test. So this is something that Justice Andrew Cheung has recently brought up, this idea that in a situation with competing fundamental rights, a court should apply the proportionality test twice, right? One in relation to the rights of the litigant, and one in relation to whatever other competing rights there may be. And Justice Cheung, of course, is our incoming Chief Justice. And in support of this double proportionality test, he refers to the now v. Campbell case, Campbell v. MGM, where there's a conflict between privacy and free expression and press freedom. So the question is, do you have any thoughts on this double proportionality test and its implications on same-sex marriage and marriage equality?
Thank you. I'm not familiar with this concept. I'd have to read more about it, but I think it's generally about situations where two human rights are potentially in conflict. So that happens in the Naomi Campbell situation. She goes to court relying on her Article 8 right to respect for her private life against a newspaper which relies on its Article 10 right to freedom of expression. So whether you call that double proportionality or not, inevitably a balance has to be struck. And that's what the European Court of Human Rights does on a case-by-case basis. So it ends up being a question of the public interest in knowing the private information. So in that particular case, it was details of Naomi Campbell's treatment for drug addiction. And the decisive factor was that the public had no real interest in knowing these details. And if they were publicized, she might stop the treatment. So that's why that case went in her favor, where you'd have other cases, for example, about let's say, a politician preaching traditional family values, and a newspaper wants to publish a story about his mistress. He's having an affair outside his marriage. So in that case, the balance might go in the other direction because of the hypocrisy involved. So that's privacy versus expression. With same-sex marriage, there's no conflict in most cases because the same-sex couple is asserting a right to freedom from discrimination in relation to their family life, and finding a violation doesn't affect anyone else's rights. But the conflict would arise in an area, I thought of including this in the lecture, but there wasn't time. Once you have a prohibition of discrimination based on sexual orientation, I hope that might happen through the sex discrimination ordinance, and you have, let's say, marriage or civil partnership for same-sex couples in Hong Kong, then you'll get a conflict of rights when religious individuals ask for exemptions from these general rules. So we've had several examples of this in Europe. First, the Ouida and others case, which included Lillian Liddell, a Christian registrar with the London Borough of Islington. Her job was marriage registrar. She was told her job had changed. She was now marriage and civil partnerships registrar, and she would be expected to register the partnerships of same-sex couples. She said this was contrary to Christian beliefs. She could not do it. She asked to be exempted. her public sector employer, refused, and she lost her job. She went to the European Court of Human Rights, and in that case, the balance was resolved in favor of the local government. They were trying to prevent discrimination based on sexual orientation, essentially direct sexual orientation discrimination against their customers. And Lillian Dell was asserting a right to be free from indirect sexual orientation discrimination because of the effect of this neutral rule on her and others sharing her beliefs. So that situation was resolved in favor of, you could say, sexual orientation in that case. Similarly, Bull versus Hall, a private hotel owned by Christians, refused a room with a double bed to two men. The UK Supreme Court said, well, there's an exception for religious organizations, but the exception excludes commercial activity. And you are a commercial enterprise, a profit-making business, therefore the exception doesn't apply. So I would say generally these conflicts can easily be resolved. The exceptions would be, for example, we had a case where a priest, a Church of England priest, got married in England, and the rules of the Church of England are that lesbian and gay priests may enter a civil partnership, but not a marriage. So because he had disobeyed the church's rules, he was denied a certain certificate he needed to be a chaplain in a hospital. And that refusal was upheld. In that case, the freedom of religion of the Church of England justified his exclusion from an employment opportunity. So anything, and similarly, any questions of who can be a priest or religious leader the balance would be struck in favor of freedom of religion. Also, each religious organization gets to decide which couples they will marry. So there's one last case I'll just mention. It's quite well known. It's the case of Lee versus Asher's Baking in Northern Ireland. So in that case, Mr. Lee, well, it was actually the commercial bakery owned by Christians that invited clients or customers to bring their own designs. And the bakery said, we will put your design on a cake. So Mr. Lee went there with his design, which featured the slogan, support gay marriage. They refused to put it on the cake. He went to court, supported by the Equality Commission for Northern Ireland. He won in the county court, the Court of Appeal, and then lost in the UK Supreme Court. His case is now pending before the European Court of Human Rights. I have just drafted a third-party intervention on behalf of several NGOs, arguing that the UK Supreme Court got it wrong, and that this balancing, in that case, it was balanced. Well, what the UK Supreme Court said was there was no discrimination because the refusal of the service was based on the content of the message, not on the sexual orientation of the customer. So we're arguing that that was a mistaken analysis. But essentially in that case, freedom of religion doesn't work because it's a commercial business, and freedom of expression doesn't really work. There is an argument about compelled speech, but you have to ask whose message is it? So the message on the cake is really the customer's message. No reasonable person would think that it's the message of the bakery. So we'll see whether the European Court of Human Rights will be persuaded. But going back to the original question, double proportionality sounds a bit complex to me. I think it's really just one balancing exercise.
I think one worry that some people have is that this double proportionality test might be less favorable LGB rights, right? So, if the question is not only can, say, the right to equality be restricted under certain circumstances, but also, if we ask, can, say, to take the Vader case, can the right to, or can the freedom to manifest one's religion be also be restricted? If we apply the proportionality test both ways, then would that undermine LGBT rights? Would cases like Holby Bull or Iweda, would they have been decided differently? It's a big question. I don't know whether you want to address that directly. We are running over a little bit, but Robert, if you're happy to continue the conversation for another couple of minutes, there are quite a few questions that people want to ask. One question is, how do you have any views on how to address a cultural or religious backlash in authoritarian regimes, which may work against the trend of recognizing the basic humanness of enduring relationships and the desire to establish such relationships? So the question of religious backlash, I suppose in places like Poland, and how one would deal with that.
That is a big problem in Poland, but it's much bigger than LGB human rights. It's a general challenge to democracy and the rule of law. So it's going to play out in many different areas, but ultimately the religious views of the majority should not make a difference. So I mentioned the pending case against Poland. So the third-party intervention asks the court to overrule its prior decision in Gazan-Dubois versus France, and essentially say to Poland, you have a choice. Either you recognize this birth certificate from the UK, which lists 2 women as the legal parents of this child, or you create a procedure for second parent adoption for same-sex couples in Poland. So that we argue that there's sufficient European consensus to support that conclusion. If the court agrees and finds a violation in that case, well, it'll be interesting to see whether Poland complies, because at the moment, the government would say absolutely not, no way. And that actually raises a bigger problem with the European Convention system, which is, it was founded on the basis that every Council of Europe member state is a democracy that respects human rights. And there was an implicit threat that a country that did not comply with judgments of the European Court of Human Rights or was not ceased to be a democracy would be expelled from the Council of Europe. And that has not been happening. So if you look at Russia, Azerbaijan, Turkey, now Poland and Hungary, there are questions about how democratic these countries are. And then also there's the question of compliance with judgments of the European Court of Human Rights. In 2003, Turkey received a veiled threat of expulsion for not complying with the judgment and complied within 3 weeks. But in 2005, the UK lost a case on prisoner voting and refused to change the law. And 12 years later, the Committee of Ministers of the Council of Europe just gave in and said, okay, you made tiny cosmetic changes to your policies, we'll accept those. So now we have this British example, which is that just ignore the European Court of Human Rights when you don't like the judgment. And that can be copied by every country in Europe. And one important situation where this is happening on an ongoing basis is LGB human rights in Russia. So in 2010, the court said in Alexeyev versus Russia that Russia must allow an LGB pride event in Moscow. That's 2010, and we're now 2020, and it hasn't happened. And Russia has no intention of changing. In fact, it's illegal under Russian federal law. It's considered homosexual propaganda. So should Russia comply with the European Court of Human Rights judgment? Well, yes, but they could say, well, we will comply when the UK complies. So yeah, so there's this sort of religious authoritarian backlash that's mentioned is a very serious problem for international human rights law altogether.
A question about civil unions versus marriages and whether strategically, in terms of kind of having some advancement in LGB rights, whether it would make more sense perhaps to go for civil unions or civil unions first before going for marriage. What do you make of that approach?
Well, it's said that half a loaf is better than none. And with civil union, civil partnership, you might actually get 90, 95, sometimes even 100%, 99% if it depends how much value you attach to the name of a loaf. So this is a question of being pragmatic versus strictly principled. The pattern in Europe has been that we have 16 countries that allow same-sex couples to marry. 15 of them had some kind of law, registered partnership, civil union, civil partnership before marriage. The only exception is Portugal. And I think in Portugal, it was because of the influence of Spain next door. Spain did have civil union type laws at the regional level before their national marriage law. So that's the pattern in Europe. In Canada and the US, it's been different, mainly because of the role of courts. So legislatures are not principled. And in Europe, we only have one country where same-sex marriage was introduced by a court. It was Austria. Otherwise, it's always been through the legislature. In Canada and the US, you have a mix. And if you can persuade a court that this is unprincipled, that a civil union is discriminatory, and they might reject it. So a good example of that is Massachusetts. Well, it was argued in Ontario and British Columbia that registered partnership civil union would be unacceptable, and the courts agreed. In Massachusetts, it was a two-stage process. November 2003, the Supreme Judicial Court, by 4-3, said that same-sex couples had a right to marry. They then received a draft bill from the Senate of the Massachusetts legislature, draft law on civil unions for same-sex couples. And the question was, is this enough? Is this okay? And the Supreme Judicial Court of Massachusetts in early 2004 said, no, we have a history of separate but equal in this country in relation to racial discrimination. And we know that separate is not equal. So that's one approach you can take, which is essentially the one that the Constitutional Court of Taiwan took. And I would say it's worth a try, but you need a plan B. So that's where civil union comes in.
Perhaps two final questions, a specific one and a more general one. So the more specific one is on Taiwan. Do you think the plebiscite in Taiwan, the referendum in Taiwan, would have been different if the ballot question had been framed differently? And the more general question is, I think from a student, and the question is, what role does education play in the advancement of LGB rights, and what can law students do to help promote LGB rights?
Okay, on the first question, when the plebiscite was held in Taiwan, I couldn't understand the question because I thought the opponents would try to amend the Constitution to override the decision of the Constitutional Court. And at the conference in Taipei last year, I was very relieved to hear that that's legally impossible in Taiwan. So they were, I think the point of the plebiscite was just to express public disapproval. I suppose if you asked the majority in Taiwan, they would prefer civil union to marriage. But the Constitutional Court said, no, it has to be marriage, and the only choice is whether it's in the civil code or outside the civil code. So that's what the voters were asked. Do you want it in the civil code? No. And so it's really a petty distinction. And I hope at some point the Taiwan Constitutional Court will say, no, it has to be in the civil code. So even in that situation, you have incremental change. So, but I suppose my main comment would be that I'm against referendums on same-sex marriage. So people will point to the ones that were held in Ireland and Australia and say, see, it was wonderful, we got a positive result. But it sets a bad precedent. There was a referendum in Slovenia in 2015. The legislature passed a law on same-sex marriage. A referendum was held and the law was overturned. So anytime you ask the majority in a referendum to grant rights to a minority that is historically despised, you're asking for trouble, and it shouldn't happen. So yeah, so that's my general view on the Taiwan vote. But as to the role of education and law students, I would say every single person has the opportunity to educate others about LGB human rights. And whenever they come across prejudice, they can challenge it. So I think what's wonderful today is that students are able to talk about these issues. So when I was a law student at McGill, there was no discussion at all. And there were no openly lesbian or gay law students. There was no LGBT law student society at all. And I was afraid to discuss it with my professors. The exams were anonymous, but I thought I might be failed somehow. I don't know how this was going to work. But so yeah, so there's been a huge change just in the ability to talk about this question. So that's where law students can make a difference. Get out there and talk and persuade and educate.
Well, on that note, I think that's a good note to end on. Thank you very much, Robert, for giving this year's lecture and for sharing your views with us. And thank you, everybody, for joining us this evening. That's all for tonight. And I wish you all a very good evening.
Thank you. The Faculty of Law looks very nice behind you, and I can't wait to visit.